you all. Thank you all. Thank you. Thank you. We're at it. My colleagues were just asking how long I'm going to speak. Just a few minutes. Just a few minutes. First, to say thank you to all of you as a grassroots force, saying that this is just wrong to pack the court through this stolen seat. And that's why it's so important that we still, in the few hours we have left, hopefully stop this really crime against the Constitution and the crime against the Supreme Court. So fill the halls after we're done here, and hopefully we'll have a few colleagues who will stop this train. This train is running over a cliff. It's taking not just the Senate with it, but the Supreme Court, and we need to apply the brakes. Let me just be absolutely clear. What happened last year was unprecedented in U.S. history. 16 times there has been a seat come open on the Supreme Court during a campaign year, a presidential year. 15 times the Senate has acted. Of that, 11 times it's confirmed a justice, 4 times it's turned the justice down, but it's always acted until last year, when within hours of the death of Antonin Scalia, the majority leader went out and said, we're not going to do our responsibility under the Constitution of advice and consent. We're going to stonewall any nomination that the president puts forward. And that is just wrong. It is so wrong. If stealing a Senate seat succeeds, it is continuous trouble for the future of consideration of nominees for a generation to come. Each and every majority, when a seat is open, is going to be tempted into whether they follow this type of irresponsible conduct, either to rebalance the court or to double down on a devilish strategy. So that's why we've been so fierce in saying no. We've also been saying fiercely no, because this is an extreme right nominee. The whole point of the 60-vote test is to send a message to a president, don't nominate from the far extreme. This president did nominate from the far extreme. You read the cases, you see the frozen trucker case, and you see that the law was designed to protect truckers when they're operating for personal safety or public safety. The trucker decided he was not going to put that trailer on the road with frozen brakes. He got fired. The entire court, except for Gorsuch, said, yes, you're protected from getting fired, but Gorsuch twisted and tortured the law to fine for the company. We see the same thing in the autistic child case, where we passed a law here in the Senate and the House and signed in the Oval Office that said that you must provide an appropriate education for a disabled child. And Gorsuch set up a new standard. He said merely more than de minimis, which means a little bit more than nothing, as his standard. And we know how the rest of the judicial system views this, because his standard was just overturned by the Supreme Court, not by a majority, but by a unanimous 8-0 vote. So I'm so pleased to be here with my colleagues to share in this conversation. And thank you to all of you, because everything important that we do requires working on the inside and to have a grassroots force on the outside. That's the only way you succeed, and we're going to fight right down to the last minute. And it's, thank you. It's my pleasure to introduce my colleague from Hawaii, and Mazie Hirono. She was so, and so welcome.
Thank you. Good morning. Good morning and aloha, everybody. We're going to start calling Jeff Merkley Marathon Man. Oh. Truly awesome. Thank you. I'm really proud to stand here with my colleagues as well as all of you. Thank you so much for your engagement and activism. It matters to us to hear from you. And believe me, all of us have been hearing from our constituents about the Gorsuch nomination. There is only one federal bench that requires 60 votes for confirmation, and that is to the United States Supreme Court. Why? Because there are only 9 justices. They are lifetime appointees. They will be making decisions that impact our lives. That's why you're all here, for decades to come. And it matters who is the 5th justice that will give that 5th vote to the Roberts Court and help the Roberts Court in their steady march to the right that supports corporate interests over individual rights. It's the Roberts Court that brought us Citizens United. And as I said last night at about 11 p.m. as I was on the floor speaking against this nomination, Justice Roberts orchestrated that outcome. That court could have decided Citizens United on a narrow, argued basis, but he caused a rehearing, and he wanted to get to the constitutional issue. And suddenly, corporations were deemed people with constitutional freedom of speech rights. It is Citizens United that opened the floodgates for unfettered millions and millions of dollars in dark money that's been poured into our elections, changing how we do politics in our country, drowning out the voices of individual people. It is the Roberts Court that also brought us Shelby County. Yet another 5-4 decision. It didn't have to result in that kind of a decision that basically gutted the Voting Rights Act, Section 5 of the Voting Rights Act, that prevented states from imposing voter suppression laws. And the Roberts Court substituted its own judgment for the hours of hearings and thousands of pages of record that Congress had established in reauthorizing the Voting Rights Act. So this is the Roberts Court. And being supported by some of the most conservative groups in our country, Judge Gorsuch will fit right in. The Heritage Foundation, the Federalist Society, these are groups that have spent over $10 million advocating and supporting Judge Gorsuch's confirmation. And they're doing this because they expect him to fit right in with the rightward trend of the Roberts Court, where protecting corporate interests is more important than protecting our individual rights. Now, Jeff mentioned a couple of cases. You know, you've all heard about the trucker case, the frozen. He had to make a choice between freezing to death and being fired, and he was fired. But you know, there's another case that not too many people have talked about, where Judge Gorsuch found a difference in an OSHA violation case where a company was fined only $5,000, and the distinction that he found between a floor opening and a floor hole was the basis on which he decided that this company didn't even need to be fined $5,000 for an OSHA violation that was supposed to protect the workers. This is the kind of justice he would be. And so there are fights that are worth fighting. This is one of them. We will continue to fight. There will be other battles to come. I thank all of you for being here, for your activism, your engagement. We need you. Thank you. Dick Blumenthal.
My name is Richard Blumenthal, and I am from Connecticut. And just a couple of weeks ago, I was here with Judge Gorsuch, and he sat literally right here. He sat here, and I sat over there. And the purpose of the hearing was really to learn what he believes. What are his core beliefs? What's his judicial philosophy? And question after question. I was sitting there, he was sitting here, he evaded, he dodged, he refused to answer. Do you believe that Brown v. Board of Education was correctly decided? Do you believe that Griswold versus Connecticut was correctly decided? Do you believe that Loving versus Virginia Lawrence versus Texas, Obergefell versus Hodges. These are not new decisions. Some of them are decades old. They are well-established, long-accepted, core constitutional cases. He evaded our questions at every turn about those cases, about other fundamental rights and liberties that are a matter of core constitutional principle. He had a special obligation to be forthcoming. He was nominated by a president who established a litmus test, who promised that his nominee would overturn Roe v. Wade automatically, his word, who would strike down gun violence prevention measures, and who would be of a distinctly conservative bent. He had an obligation to answer those questions. And also because he was screened and proposed by far-right conservative groups like the Heritage Foundation. Donald Trump outsourced his selection of a Supreme Court nominee. Neil Gorsuch, evading those questions, left us with the inescapable conclusion that he must adhere to the Trump litmus test and to the agenda of those far-right groups. But equally important, that he would adopt a judicial philosophy, which he's articulated in his writings, that would substitute the judgments of the courts for the agencies that enforce key rules. They are rules that protect our air and water, workers when they go to their jobs, consumers when they buy stuff, privacy rights. These kinds of rules are essential to enforcing basic rules. And Neil Gorsuch, in saying that he doubted the validity of the Chevron doctrine, is saying, in effect, courts should substitute their views for those rules and, in effect, overrule the legislature. So this issue is deeply and profoundly serious to the American people, the future of the court and the future of America. If you have any doubt about why you are here, you should be proud, because you are fighting for basic American values. You're fighting for you're fighting for the rule of law. And to anybody tells you, well, you know, it looks like you're going to lose, you look them right back and you say, if Trump wins, it will only because he wrecked the rules. He changed the rules so he could win. And he was aided and abetted by the Republican leadership. They didn't win playing by the rules. They had to change the rules. And those rules, the 60-vote threshold, there's a reason for that rule. Justices on the Supreme Court, there are 9 of them. Every vote is important. Every vote is a swing vote. Every vote is a sway vote. They can sway colleagues. And for a lifetime appointment on the nation's highest court, there ought to be more than a razor-thin majority. It ought to be by a bipartisan consensus. And that was the tradition, that presidents would consult both sides of the aisle before they made a nomination, not outsourcing them to far-right extreme groups, not establishing a litmus test, not proposing someone who would evade questions. Even Justices Alito and Kennedy and Chief Justice Roberts came to this place and answered those questions, saying they agreed with those precedents. It is unprecedented for a nominee to be so evasive. So we're here to say principle and conviction and conscience count for something. We may lose today, but we win in adhering to basic core principle and conscience. And we are going to continue. We're going to continue fighting for a woman's right to determine her reproductive decisions. We're going to continue fighting for same-sex couples and their right to marry the person they love. We're going to continue fighting for the workers who go to their jobs every day and they expect to be safe and come home to their wives and children. And for consumers who expect that the products they buy won't kill or injure them. Those rules are all important, and many others. We're going to continue this fight with your help, and you will, in the long run, you will help us win this battle. Thank you for being here today. Thank you for all you are doing. And I now want to introduce a great colleague who has an extraordinary record of fighting for people, my great colleague, Chris Van Hollen.
Thank you. Thank you. Thank you, Senator Blumenthal, for your leadership. It's great to be here with my colleagues, great to be here with all of you as we face this really critical point in the history of the Supreme Court and the direction of the country, because we've learned that any one of those 9 Supreme Court justices can literally change the direction of our democracy and the course of history. Our senators here have talked about a number of the 5-4 decisions. This decision that took a big bite out of the Voting Rights Act and immediately led to many states around the country enacting discriminatory laws to try to prevent people from having access to the ballot box, especially targeting African Americans and minority voters. 5-4 decision in Citizens United. So any one of those 9 Supreme Court justices can literally change the direction of our country. And that's why this is so important. And it's not enough to be a good lawyer. Yeah, Neil Gorsuch is a good lawyer. There are lots of good lawyers out there. And as Senator Blumenthal said, he was very artful in answering questions where he talked a lot but said nothing of substance. It was all platitudes. So it's not enough to be a good lawyer. The question is, what does this appointment mean for the future of the Supreme Court and the future direction of our country? And when you dig into the records, as all of our colleagues have done with great seriousness, you find that Neil Gorsuch is somebody who actually has a very fixed political ideology. And it is an ideology on the far right. He is somebody who consistently sides with powerful corporate special interests against the rights of workers and against the rights of individual Americans. And that was the conclusion of a number of analyses that appeared recently. You may have seen the analysis in the New York Times that went through all the Gorsuch decisions and concluded that he would be the second most conservative member of the current Supreme Court, only Clarence Thomas, Justice Thomas, being more conservative. And then there was a Washington Post analysis that concluded that he would actually be to the right of Justice Clarence Thomas. So it's fine to be able to answer questions in a smooth way, but the question for the country is, when you look at this person's record, where will it lead us? And when you do that analysis, you find that he is going to be far to the right. Now, none of us should be surprised, because he was never intended to be a mainstream candidate. As my colleague said, this process was literally contracted out by Donald Trump to far-right groups, the Heritage Foundation, the Federalist Society, and others, and contracted out with some litmus tests that were put out there. Somebody who would not support a woman's right to reproductive choice, someone who would be friendly to the NRA. And so it should not come as a surprise that when those groups came up with a list of 20 names, Neil Gorsuch was on their list, that he makes them very happy. Shouldn't be a surprise to any of us. And of course, President Trump then dutifully picked his name off the list that had been compiled by these right-wing groups. And right after that, you saw the right-wing money machine kick into gear, spending over $10 million to try to make sure that Neil Gorsuch ends up on the Supreme Court. Judge Gorsuch was asked, why do you think people are spending $10 million to put you on the Supreme Court? He said he had no idea. Well, I can tell you why. It's because all those powerful special interest groups want somebody who's going to consistently side with big corporate special interests against the rights of workers and against the rights of individuals. That's why they're spending $10 million plus on this race. So yes, we're in a hell of a fight, and he is not a mainstream candidate. And that is why we have the rule in the Senate requiring 60 votes, because you want somebody who's going to be able to achieve at least some consensus. And enough the 60-vote threshold is there for a purpose. So this is why we've been saying from the beginning, let's go back to the drawing board. Let's come up with somebody who can achieve that consensus. Don't change the rules that are there for a purpose. Change the candidate. Change the nominee. All right?
Do we have any questions? Yes?
Senators, do you have any reaction to Chairman Nunes announcing this morning that he was going to step aside from the Russia investigation?
A terrific decision. Anyone else want to add anything? What was the question? I think it's so important that we get to the bottom of this. In fact, we shouldn't be considering a nominee to the Supreme Court at the same moment that the president's team is under investigation. We know that Russia engaged in serious, extensive tactics to sway the election. We know that. That was an act of war against the United States. What we don't know is how much or if the Trump campaign conspired, cooperated, collaborated with that effort. But if, in fact, that happened, it is treasonous activity and must be pursued to the full extent of the law.
So, this question is really important because we are casting this vote today in the midst of a looming constitutional crisis. The FBI director has said his agency is investigating association and collusion, potentially, between Trump associates and that Russian meddling. And at the same time, Donald Trump is denouncing and castigating judges on the courts. He is demeaning and degrading the independence of the judiciary. The bulwark against tyranny is an independent judiciary. We need somebody on the Supreme Court who will be independent and who will defend the independence of the court, which Neil Gorsuch failed to do as he sat here. I asked him, will you denounce Donald Trump's degrading and demeaning of our courts? And he said it was disheartening. He said it was demoralizing for anybody to do it, but he would not specifically say that about Donald Trump's attacks on the courts. Now, we may see for the first time in recent history a Supreme Court having to enforce a subpoena against the President of the United States. It happened in United States v. Nixon. It could happen again, because if the FBI needs a subpoena enforced, they will have to go to the courts and eventually maybe appeal to the Supreme Court, where this nominee then will sit. having failed to forthrightly and directly criticize the president for attacking the court. This issue is profoundly important to the future of our country. And the independence of the judiciary is critically important at this moment in our history, and so is the need for a special prosecutor.
Yes.
On the day on the very day that the Judiciary Committee, where I sit, approved Neil Gorsuch's nomination, we also voted on the nomination of the Deputy Attorney General, Rod Rosenstein. And I voted against him because he refused to commit to me that he would appoint a special prosecutor. I want that commitment from the Department of Justice, that a special prosecutor will be appointed, because only a special prosecutor can enforce the criminal laws, can bring criminal charges if they are warranted, can follow the evidence of criminal wrongdoing wherever it goes. The intelligence committees can't do it. An independent commission can't do it. We need a special prosecutor. So all of these issues are linked together, and all of them are critical to the future of our democracy.
Can I just add something? It's all of a piece. We have an administration and a president that deals in alternative facts. So we get a Supreme Court nominee who is told to us as a moderate, and he is not. Regarding the Russian interference with our election and any connections with the Trump team, nothing to see here. That's what we're told. When we had the hearing with Jeff Sessions, our Attorney General, one of the concerns I had was the 20 or so consent decrees that the Justice Department has with police departments across the country, after a showing of a pattern and practice of police misconduct. I asked Jeff Sessions, would you adhere to those negotiated settlements, consent decrees? And he wouldn't respond. And guess what? Just recently, he is now reviewing all of these consent decrees. We need to remain engaged. We need to pay attention to what this administration is doing, the way they're proceeding that really cuts back on protections for all of us versus some really powerful special interests. Thank you.
Ms. Turner? Could you all hear that question? Given that Stonewall and Merrick Garland, if Neil Gorsuch is stopped, what makes us think the president will pick somebody more moderate? If the Republican team here in the Senate has the courage to protect the Senate as an institution and the court, and to stand by the 60-vote standard that has served us so well over time, if they have that courage, then they will send a message to the president that you need to send someone in the mainstream of judicial thought. But it comes back to the fact we don't know. In fact, we're quite uncertain that the majority has that courage to protect the institution because of what they did last year to Merrick Garland, stealing the seat, sending it forward into the future in hopes of packing the court. But it is our responsibility as senators who took the oath of office, who said we would maintain the advice and consent responsibility given to us in the Constitution. It's for us to stand by our oath, to protect this institution, to protect the court, and fight this battle to the end and beyond. Do we have time for one or two more questions? Yeah. One or two more questions. Do we have anything from the press, or that? Then I'll turn to you. Yes.
Yes, hi. I understood that shouldn't it take 60 votes to change the filibuster rules? Wasn't that at one point the case in the Senate that in order to change those filibuster rules, it was a 60-vote majority?
The mysteries of Senate rules confound America perhaps no more in any location than the filibuster. And indeed, so the basic story is that you can ask a question of the chair, does a rule apply in this situation? And the chair will say, yes, the rule does apply. And then the majority leader can challenge the ruling of the chair and overturn that ruling with 51 votes. So that's how it happens. That's the short version is the rule doesn't change, the interpretation and application of the rule changes. Yes?
If the 60-vote majority, supermajority, is so important to you, as you guys have been talking about, if you were to win the majority set it back, would you change the rule back?
Well, a question that would take us into the future. What we realize is that we can't have one set of rules when the Republicans are in charge and a different set of rules when the Democrats are in charge, if it means continuously give a bias in favor of Republican ability to paralyze Democrats and takes away tools that we might have. So it's a difficult question that we would have to wrestle with as we go back. Hopefully, the Senate majority will come to its senses and leave this rule in place. It's that important. Is there anything you want to add on that? We can't unilaterally disarm, which has been a question that has been put forward. We tend to believe that we need to make government work. We don't believe, well, I'll put it this way. Mahatma Gandhi said, if all you do is operate an eye for an eye, the whole world goes blind. We need to have Democrats and Republicans come together and say we are ready to solve the problems facing America. Advance and improve health care, advance and improve infrastructure, advance and improve tax structure. And if we don't, then we are going to leave America behind. But that means we need to have cooperation from a team that has shown no cooperation. This is the last question. We don't regret it at all. And I'll tell you why. What happened was that the advice and consent tool was used by the Republican team as a tool to inflict damage on President Obama because he was of a different party and on the judiciary. And they did so repeatedly over several years and intensified it where we couldn't get a labor secretary. We couldn't get people on the National Labor Relations Board. We couldn't get a vote on key judges. And we negotiated. We pushed. We even had a session in the old Senate chamber where everyone bared their souls. And the Republicans said, we know we're misbehaving. We know we're destroying the institution. Okay, we'll stop. And then a month later, they said there are 3 seats on the D.C. Circuit Court, and we're not going to let President Obama have a debate over anyone he appoints, no matter what their background. And that was the first echo, if you will, of the steal the seat strategy. And that's what forced us to have to change the rule on all nominations except the Supreme Court. It's so important to leave the supermajority in place for the Supreme Court. Other levels make decisions, but they get bumped up to the Supreme Court. That's where the buck stops. You want to have bipartisan buy-in, and that's why we left that rule in place. But we did the right thing in 2013.
Thanks, everyone.